right, sir, are you Thomas Johnson?
Yes, ma'am.
And Mr. Johnson, this is your initial appearance in cause number 24 DCCR 2265. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from September 8th of 2024.
Yes.
Since you've made bond, have you had an opportunity to try to hire a lawyer?
I have not.
Okay. What do you mean when you say you've had a long morning already?
My foot. I had some metal fall on it yesterday, so everywhere I'm going, I'm hobbling around, so it's just hard to get around on it right now.
Okay. Give me just a second to check something.
It makes for moving not so pleasant.
Did I test you this morning and have anything in your system?
No.
Let's double that before we go forward. Have a seat over in the jury box, please. Don't guzzle it to where you make yourself sick. Just drink some water like a normal person and then go use the bathroom. It's not that hard. It doesn't show a state's attorney on that one.
Wait, hold on, I just got it. I just put it in.
The PC on that one?
Hold on.
The high-speed chase was crazy. I wonder whose it is. I mean, like 100 miles an hour down 105. They went from here to Hardin County and back and jumped out and ran in the woods and threw out drugs. So, all right, Mr. Johnson, come on up. Mr. Johnson, in cause number 24, DCCR 2265, we've already gone through this, but you're charged with evading arrest or detention with the use of a vehicle. I have reviewed the pre-sentence report in your case. Based on that report and the fact that there is an allegation, obviously an allegation of a high-speed, very dangerous chase, but in addition to that, there's an allegation that drugs were thrown out of the vehicle during that chase, and that's why I ordered the drug test this morning. It's now 11 o'clock. I ordered this drug test prior to 9 o'clock. You have not been able to go or refuse to go to the restroom. Based on that, I am going to find that I'm going to assume that you are positive and that it is in the best interest of our community that I raise your bond, which is currently set at, give me just a second to figure that out.
It was at 10,000.
10,000.
Yes,
I'm going to raise your bond in your case to $30,000. A condition of that bond, if you make it, is that you wear a drug patch at all times. You will have 24 hours from the time you are released, if you make that bond, to have a drug patch put on. Your bondsman can let you know where to do that. You have to change it every 2 weeks. If it tests positive, you would be right back in custody, obviously. If it's not testable, then it's also going to be considered a positive drug screen. You can go back with the bailiff. Not today, not now. All right, Mr. Harris on Camden Jackson.
Yes, Honor.
Good morning, sir.
Good morning.
It's still morning, barely.
Barely. Judge, did you want?
Yes, sir, thank you. And they told you about sending the attachment in?
Yes, Your Honor.
Okay. Thank you, Ms. Malfino. All right, sir, are you Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor. And apologies for my handwriting because it's horrible.
It's hard on the tablet. You're good. All right. So you're charged in cause number 25 DCCR 0114 with the second degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment, or like ISF or something like that. And it looks like that's what the state's going to be requesting. Do you understand? And that decision's up to me when we come back for sentencing. All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to recite your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick, jail incident reports and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with the co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment if that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been
Yes.
absolutely ridiculous acting up in the jail. So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say, because y'all are all out there. It's the same group that's doing the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one between right now and your sentencing, I will not accept this plea agreement. I'm sick of it. The jail's sick of it. And I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? One. We're not going to come in and say it was somebody else's fault. I only got 1 or I got 3 and that's not that bad. You can go out there and tell them, I want to get out and be on probation. I don't care what you guys want to do. I'm going to behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks, rest of your life. What do you think? Show me you can do it, okay? All right, and go back with the bailiff.
Thank you, Your Honor.
Yes, sir. Yeah, the last one was May 17th. So,
Thank you, Ms. Flores.
so it hasn't stopped.
It will stop. Please,
Well,
this report back.
we'll see.
I'm threatening.
We'll see. I hope so. I hope they're having an easier time out of the jail.
That's what I'm thinking. I wonder what's up.
What's that? What is, you're Carly Davis and Carly Hoosier. And this is 24 DCCR 1385 and 25 DCCR 1237. And so we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that one?
In both cases, Judge.
Let me pull this up. I know I took a look at it last week, but.
This one's charged.
And so we've got both of these cases are driving while intoxicated, 3rd or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. So we've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for,
All right, it shows it expires October 31st for the,
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Millburn, Texas address for this. doctor when I looked him up through the Texas Medical Board, and I'm just a little curious about.
So where do you go to the doctor? Where's this doctor from?
From Beaumont. And I do a telemed every month except every 3 months. I go to his office now. I have an appointment with him today now.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh,
Yes,
well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving? Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay? So if you're caught driving, obviously you'll be right back in jail probably without a bond. Mr. Coleman, other than a no driving, is there any other?
No, Judge, I just would like to reiterate, and we put it in our motion, and it sounds like the court's read the motion, but, she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI.
Right.
Judge. And that, along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion, so that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, tell her free to go.